Let's have a look at how disputes in construction are resolved. For a dispute to arise, there has to be a claim that is made, and that claim has to be of some kind. Examples of claims are claims for variations, claims for progress payments, claims for damages, for breach of contracts. And due to these claims, there will be a disagreement. So one party makes a claim, and then the other party disagrees about the claim. And that gives rise to a dispute. When there are standard forms that are involved, so if there's a standard form contract, these contracts would specify how disputes are resolved. And so, for AS 4000, for instance, there's a clause that specifies that arbitration is required if the dispute is not resolved within 28 days. These clauses are referred to as dispute resolution clauses. Most disputes that arise in construction are due to progress claims. So parties not agreeing on the exact value for a progress claim, and usually the party claiming the progress claim needs to resolve the issue promptly. So they need to receive the payment quickly. Usually contract is short in cash or short in cash flow, and they need that money. Under the Security of Payment Act, the claimant is required to submit an adjudication application within 20 business days after the due date for the payment has passed. So contractor requests a payment, the principal does not pay the money, and 20 business days after the due date, the contractor has to submit an application for adjudication to resolve the dispute. In the majority of dispute resolution clauses, the claimant, so the person claiming or claiming an amount, say for instance in a claim for a progress payment, needs to notify the other party about the nature of the dispute. And that will be specified in any dispute resolution clauses that are present in contracts. Now, in terms of resolving disputes, there are several ways, and you can see some of them mentioned on the screen in front of you. So negotiation is one way, mediation is another way, expert determination, and arbitration. Let's have a close look at each of these. Starting off with negotiation. What is negotiation? Negotiation is where parties are required to sit down and negotiate with one another. Now, the dispute resolution clause can specify that negotiation is to take place between senior executives from each party, and the clause would specify that the negotiation has to take place in good faith, where both parties have to have an open mind and a willingness to resolve the dispute. It's the simplest resolution clause, and negotiation, when it's specified as a dispute resolution, is usually not binding. The second approach of resolving disputes is through mediation. Mediation is assisted negotiation, and that's where you have a third party, the mediator, that assists the negotiation. So you have a third party, and that third party would be assigned, so both parties would agree that that third party would be present in the negotiations, and they would help sort of direct the negotiations and help both parties to achieve a particular solution. Again, mediation is not binding. The third dispute resolution mechanism is through utilizing an expert, so expert determination. An example of that would be where the parties disagree on the value of a variation, so they argue about the value of a variation, and in this case they can both agree that they would get an expert, a quantity surveyor, and that quantity surveyor appointed through the agreement of the two parties that are involved in the dispute would give their expert opinion, and that decision that they come up with would be binding. So both parties would have to respect the decision, and they have to abide by the recommendation that's given by the expert. Finally, arbitration, and that's the most formal method of dispute resolution. It's where there's a third party, the arbitrator, and they help resolve the issue that had taken place between the parties involved. The decision of the arbitrator is binding, and the arbitration process would be governed by the Commercial Arbitration Act 2010 in New South Wales. Now, the outcome that the arbitrator comes up with is referred to as an award, and this award is final and binding. As I said, there's very limited scope to appeal from both parties. So both parties would find it very difficult to appeal the decision of the arbitrator. Okay, so these were some of the most common mechanisms for resolving disputes. What if you had a dispute that arose due to a building claim from a residential project? In this case, you can refer your claim to a tribunal, specifically the New South Wales Civil and Administration Tribunal, and claims up to $500,000 can be reviewed by the tribunal to help come up with a particular resolution. Now, the decisions made by the tribunal are usually binding. Finally, when it comes to litigation, so we're talking about suing a party, so suing a specific party in court. If that were to take place, then a stay of court proceedings may be ordered. That's where the court orders that the proceeding be halted, sometimes permanently, until both parties try to resolve the dispute in accordance with the dispute resolution clause. So if the dispute resolution clause specifies that negotiation has to take place, then they must demonstrate that negotiation had taken place and they failed to come up with a particular decision or a particular resolution for the issue. If the dispute resolution clause had specified that an expert was to be appointed and the party that's making the claim cannot sue the other party if they hadn't had an expert come in and give a particular determination on the cause. So this is what we refer to by a stay of the court proceedings.